Your Lordship, may I be permitted to mention two execution matters for inclusion in the list?
Execution matter.
Your Lordship, if I may have your kind leave to mention AP 162 of 2025. It's Section 29 application. The last order, the name of the arbitrator has been wrongly recorded as Miss Urmila Bhattacharya instead of Miss Urmila Chakrabarti.
We mentioned.
Wait for your Lordship.
We mentioned. Allot the list. Having regard to the arbitration agreement, the governing ICC rules the conduct of the parties and the settled principle for determining the juridical seat of arbitration. The court at Calcutta possessed territorial jurisdiction under Section 21E of the Arbitration and Conciliation Act to entertain the present petition. The respondent's preliminary objection on the ground of lack of territorial jurisdiction is thereby rejected. Insofar as the petitioner seeks to impugn the order of the learned tribunal refusing amendment of the statement of defense, the court finds that the said order is purely procedural in nature, does not determine any substantive right of the parties, and falls neither within the ambit of interim award nor within the category of appealable orders under Section 37. Such challenge is therefore not maintainable at this interlocutory stage. In view thereof, the present petition is dismissed.
Obliged.
Just.
একটা দুই একসাথে লিখে দিয়েছি, হ্যাঁ। ওনারই একসাথে হয়েছে,
Order to action.
ওনারই একসাথে হয়েছে, কিন্তু খাতার কারণটা আলাদা। Not interfered with the British note করলো, তারপরে আমি জানি।
In view of the aforesaid dismissal, the present petition seeking stay of the enforcement of the interim award no longer survives and is accordingly dismissed as infructuous.
So very obliged.
Matter for judgment, item number 1.
For the foregoing reason, this court is of the concerned view that the impugned arbitral award dated 13/6/2016 suffers from patent illegality appearing on the face of the record and is accordingly liable to be set aside under Section 34 of the Arbitration Conciliation Act. The arbitral award is hereby set aside. The party are at liberty to take appropriate steps in accordance with law for the appointment of a fresh arbitrator if so advised, With these observations, the present petition is allowed.
Can I go through the agenda?
Contradiction item number 3, related.
I made pulling the award holder lordship. The matter has been settled between the parties. I'm praying for withdrawal. And there's the interim order against auditor number 2. I'm praying for interim order should be vacated.
Take down. Learned Counsel petition seeks to withdraw the present petition. The same is dismissed as withdrawn. All interim orders, if any, stands vacated. Dismissed.
Original.
4 is
The settlement.
not bad.
There are three prominent real estate groups.
Yes.
My lord, had certain joint ventures.
Yes.
As usual, my lord, they started fighting. Now, one of the three settled at the Section 9 stage and my lord went out. So the my lord, two groups continued fighting. Now, their fight was also threatening that earlier settlement. But ultimately, everything thrashed out and my lord, parties, affected parties, everybody. Now, two very important things I must bring to your lordship's notice. Number one is that your lordship will see the signatures, my lord, at page 45. These, my lord, are the parties and their
Page
advocates.
45 of
45 of the terms of settlement, my lord.
yes.
Advocates have signed.
Yes.
The advocates have also signed.
Yes.
My lord, Order 23, Rule 1, my lord. Normally, even in, my lord, our district courts, my lord, we file an application. But the original side practice is to stamp punch, my lord, and produce before the Honorable Court the terms of settlement. So, my lord, which is why, my lord, Order 23, Rule 1 application is not filed on the original side. And we come with the terms of settlement. Terms are, my lord, stamped punched, and, my lord, signed by parties and their advocates. So that's full
Okay.
compliance. That's what is usually done. Now, where, my lord, what I should, my lord, bring to your lordship's notice is, my lord, paragraph 34 at page 44. That parties shall jointly file these terms of settlement in the instant proceeding and shall jointly pray before this honorable court to take these terms on terms of settlement on record, to record the agreement and consent of all parties that the award be set aside, to make these terms part of the final order by which the proceedings be disposed of. So, my lord, what had happened was the two warring groups, my lord, had gone to an arbitration, award passed, challenge, my lord, in court. And in this proceeding, my lord, we are filing the terms of settlement. Award getting nullified, this, my lord, is, and this is mostly implemented. All the share transfers, my lord, between the landowner companies, etc., all that has happened. Few things, my lord, left, which, my lord, we expect the parties to, my lord, comply. And
Where's the other side?
the other side.
Who's on the other side? Mr.
My lord,
Chaudhary?
would your lordship be pleased to, my lord, before rising at 1:15, permit me to mention the matter, bring them. My lord,
I
let
think
the
that's
terms be there. I'll bring them and do it. They should have been here, my lord.
They should have been here.
Yes,
That we
and
record
terms of settlement being placed in court, it's essential that both parties
both
are
the
here.
parties are there. Correct.
My lord, I'll will not come at 1:15, my lord, if your lordship. Grateful.
Pass over.
You respond. No, I'm not for the bank. I'm for this Mahindra case. May it please your lordship, my lord, I'm for the
petitioner.
I'm for the judgment debtor. My lord, on the last occasion, your lordship has been pleased to direct the officer concerned, it's a government concern, my lord, to be present before my lord.
Yes.
My lord, your lordship has also expressed your lordship's dissatisfaction with regard to the way the matter has been handled, my lord.
Yes.
My lord, I will not be able to justify that the matter has been handled in a very casual manner all this while, but there has been a change in the set of counsel now, my lord. A new set has come in. My lord, what I was only praying before my lord is that the decree that is sought to be executed is for an amount of 18 crores. My lord, the decree is from an award. The
Is that
original,
42 lakhs one?
my lord, yes, my lord. Your lordship remembers, my lord, 42 lakhs.
Yes.
42 lakhs, my lord, decree is of 18 crores. Mostly, my lord, on the basis of delayed interest. My lord, but it is admitted that 98.2% of the principal sum of nearly 2 crores and 50 lakhs has already been paid. Even before the dispute, 42 lakhs remains to be paid. My lord, and there at the time of acceptance, my lord, of this payment, there was not, my lord, any condition made by the recipient that this is being accepted subject to the delayed payment. My lord, they had accepted that in toto, in full satisfaction. In spite of that, my lord, in 2 sittings, the learned arbitrator, my lord, in 2 sittings has been pleased to pass the award of 18 crores. We have not had the opportunity of making our case. My lord, after the passing of the award, we filed a Section 34 application, which, my lord, got dismissed, my lord, and we have made an application for restoration. I was only beseeching, my lord, inasmuch as, my lord, public money is, my lord, involved.
Whose fault is it?
My lord,
Whose fault is it?
well, our fault.
Who's wasting the public money?
My lord,
Who's wasting the public money?
my lord, we are trying not to get it wasted. My lord, we are trying our best. I was only humbly praying this. I
Sir,
was only humbly praying this. If your lordship will
if you are trying your best, you can see what you have done.
no, my lord,
Best is the reason why it is 18 crores is because of whom?
my lord,
Whose fault is it?
my lord, I'll tell you, lordship. My lord, we have not had the opportunity of placing our case before the learned arbitrator. In 2 sittings, the arbitration got over, and the award of 18 crores has been, my lord, has come.
No, the award of 18 crores has not come. The award is only for 42 lakhs.
The interest sum.
Interest sum.
The interest sum, the award has been of 18 crores. So, my lord, I was only beseeching your lordship that Section 34, your lordship will kindly give us some time to, my lord, get that Section 34
Your lordship.
heard. You'll get your opportunity. May I? I know my learned friend is in a very advantageous position than that of mine. My lord, we sometimes face these difficulties, but I was only beseeching this. My lord, I'm not justifying the, my lord, manner in which it has been dealt with all this while. I'm not justifying. Your lordship will kindly not take me amiss. I was only just praying before my lord that your lordship will kindly give us an opportunity of getting that Section 34 heard. The amount of money, my lord, that is to be deposited. My lord, now I understand the present gentleman who has come into the post through various correspondence with his high authorities. He does not have the personal ability to, my lord, get this money sanctioned. My lord, he has had made various communication, and he has been able to convince his higher authorities to get that money deposited to enable us to get that Section 34 heard. So, my lord, I was only praying that if your lordship kindly gives us some time, that we get that Section 34 heard, because, my lord, it is our belief that the Section 34 has a lot of merit.
Your section 34 has been dismissed for default.
Yes, my
And
lord, the
also for
resolution is
non-compliance.
pending.
Also for non-compliance of order
Also
as to
for non-compliance.
Yes,
My lord, we have been able to convince the higher authorities to get that amount of 75%.
75%,
paid.
specifically 18 crores. My lord. My lord is
Yes,
recorded.
yes, my lord, that so that my lord, the section 34 can be heard. My lord,
So when will you deposit that amount?
my lord, your lordship will kindly give us 6 weeks time, my
They will
lord.
kindly hear
6
me.
weeks.
That's correct.
My lord, I was only saying that if your lordship kindly gives us 6 weeks time, at the most we will get it done. Your lordship knows I'm not saying that the government department has to be treated as to be a favored litigant, but your lordship knows the practicability. If your lordship gives us some time, we'll deposit that money, we'll get that section 34 heard.
Why,
That is my earnest
why
prayer.
6 weeks?
My lord.
Why 6 weeks? Do it before. Do it in 2 weeks' time.
My lord, that may not be possible. We
Why?
would not like to trouble your lordship, my lord, by
Why
coming
not
every time.
possible?
My lord,
You have been sitting
my lord,
over it for years together. Why it's
yes,
not
my lord,
possible?
I will not be able to justify this my attitude.
You have to
My lord, it's just that this new incumbent to the post has been making communication to the higher authorities, and that has, my lord, borne some fruit. My lord, these are all the communications that he has been doing sincerely. I was only praying, if your lordship, so that we don't come and trouble your lordship every time.
No, you do it in 4 weeks. Why should I give you 6 weeks' time?
I was only praying for the sake of abundant caution, so that we don't need to trouble your lordship every time. My lord, once for all, if your lordship gives us 6 weeks' time, we'll get it done. We'll get the section 34 heard, and thereafter, my lord, my learned friend, if we
Section 34 is also here in this court.
Not listed today. It will be before my lord. Two things. After my learned senior friend completes, my lord, will
Yes,
grant
yes,
me only
please,
2 minutes
please.
time. Let my learned senior friend.
this is my earnest prayer before my lord.
Two things. Number one, my lord, the award was challenged by you for Section 34 application. 75% is the mandatory statute for deposit for an MSME award to be challenged. That our humble contention is, and we are supported by judgments of various high courts, my lord, that 75% deposit and filing of the 34 has to be within the time period stipulated under 34(3). Now, if today they deposit, I do not mind if it is without prejudice to my rights, because I'm indicating to my learned senior friend, I will be taking the point that the deposit made beyond the period of 120 days renders the 34 not maintainable. Even so, the 34 cannot be entertained, because the language of Section 19 of the MSME Act specifically says the 34 is a non-existent entity until the deposit is made. So, my lord, if they want to deposit, I don't stand in the way. If money comes in, I have no difficulty. But that has to be made without prejudice to my rights in the 34, my lord. Number one. Number two, my lord, what is most important today, my lord, this is returnable after a detailed order has been passed by my lord on 28th November 2025. So far as our knowledge is concerned, my lord, this order has not yet been complied with by the banks. My lord had directed several. One second, sir. My lord had directed several banks, including Central Bank, Axis Bank, and State Bank, to remit the amounts lying in particular bank accounts which have been enumerated by my lord in my client's favor. We have received an amount that is less than what was lying in the specific bank accounts recorded by my lord's order. My lord, affidavits to that effect were supposed to be filed. If my lord takes the last portion of my lord's order, the ordering portion, in fact, well, I'll indicate what my lord has ordered. Page 8 of my lord's order of 28th November, if my lord has. I'll only place paragraph 2. Paragraph 2. The managers of State Bank of India, Darjeeling and Kashiong branches, Axis Bank, Darjeeling, Kashiong and Kalimpong branches, and Central Bank of India, Darjeeling shall immediately effect transfer of the funds as directed above. They shall also file affidavits before this court disclosing the exact balance lying in the said bank accounts as on the date and time of execution of this order and confirming the precise amount to be transferred. We have
I am appearing on behalf of the State Bank of India, Darjeeling and Kashiong Bank. We have already complied with the of your order.
I have not been served with any affidavit.
I will serve.
Not only one
Another
submission, I am for Central Bank. This is the affidavit. 12,71,000 was lying
We
to
have
our credit. We have
served.
transferred it. We have filed the affidavit, served the copy on my learned friend and my
Only one bank has served. My learned senior friend for Central Bank has served.
Copies.
The rest of the banks have not complied with this
State
order.
Bank has done it.
State
Central
Bank
Bank
has not.
So now the only one is Axis Bank.
Axis Bank, who is not appearing today. We have communicated specifically my lord's order.
He's
I am from the Axis Bank. I am
Yes.
led by my senior counsel, Advocate Devtonai Banerjee, sir. And
Where
my
is he?
lord, I haven't yet get any kind of instruction from the client actually.
That's non-compliance
Kindly.
order, right? My lord,
The order which has been passed by this court.
we've communicated it immediately.
Yes.
other instructional Axis Bank को टका remit होएगा.
Now, what I'm on, my lord,
Our
that-
instructions are, my lord, that money has been remitted from Axis Bank as well. That's on instruction. I'm saying
Only one more
they have
thing,
to file their application.
only one thing, my lord.
Darjeeling.
In the
Darjeeling.
account of the judgment debtor, my lord, there is 25%, 25 paisa credit as on today. We do not have any further funds.
So, my lord, let us come back after producing the affidavits. But in the meantime, my lord, I have one more humble prayer, my lord. One more humble prayer only. My lord, on the last occasion when my lord was passing this order, I had indicated my client is suffering from serious financial stringency. Serious in the sense, today we are facing demands from banks which go up to about 11 crores and all. So today there was a direction of this court to deposit 18 crores. I prayed for, my lord, release of the entire sum. My lord has been pleased to direct transfer of approximately around 3 or 4 crores was the total amount lying in the particular bank account stated or rather enumerated by my lord. The banks have not, and I will show that from the affidavits, have not complied with this. The entire amount has not come to me. But my humble prayer is, whatever deposit they made, let that be made not to the registrar. Let them pay this amount and satisfy the award. Because
My lord,
today there is
that
no
would
section
make my
34.
Section 34
That
There
would make
there
the
is no
34.
section 34 in the eye of law today, my lord. They've not even moved
That
the
we will deal with. That we'll deal with. We
section
have many
34
things to
is
say on that.
dismissed.
Can't be done, can't be done.
We have
That's
many
my
things to
humble
say
prayer.
on
My lord
that.
will kindly, then my lord will kindly restrict the timelines, or else, my lord, I am suffering seriously, my lord. It's an award of 2023. It's an award of 2023, my lord. I'm facing demands from the This is my humble plight, my lord. This is my plight.
2023 is nothing, sir.
I
You have
appreciate,
already
my lord.
got some money.
I appreciate,
My
my
lord,
lord.
salaries are all being stuck. We're not being able to disburse the salaries.
Page number
Yeah.
4, paragraph 8, I have already stated that I have complied with the order of the Honorable Court, my lord.
Okay.
Page 4, paragraph 8, my lord.
So, of your affidavit.
Of my affidavit, my lord. I'll consider.
তুমি একটা কপি দিও
Copy, so I have one copy and the
সমান কাকে দেবে তুমি একটু বলে দিও উনি দিলেন দুটো দিয়ে দিন
All right, take down. The affidavits. Affidavit of compliance filed by the Chief Manager, State Bank of India, Darjeeling branch is taken on record. Affidavit of compliance on behalf of Chief Manager, State Bank of India, Kurseong branch is also taken on record. Full stop. A copy of both the affidavits have been handed over to the counsel for the petitioner. Stop. Affidavit on behalf of the Central Bank of India. Affidavit of compliance on behalf of the Central Bank of India is also taken on record. A copy of the same has been handed over to the counsel for the petitioner. Full stop. List the matter on. You want it after 6 weeks.
My lord, my prayer would be a little shorter time, my lord, because I am in, my lord, I am suffering, my lord.
want to get money, no?
Yes.
The government department. Give it after 6 weeks.
Last order direction.
My lord, in the meantime, my lord, if a direction can be passed for the banks to comply with this order, nothing more.
Bank is
Because
complying with the
it
order.
has not been, well, Axis Bank has not yet filed an affidavit.
File-
Today, State Bank, my lord, has
File a
filed.
reply if you want to.
My lord, we'll do so. We'll take the appropriate steps, my lord.
My lord, your lordship was pleased to direct the Executive Director, Public Health Department to be present before my lord. He is here, my lord.
My lord, that could
On the
also,
last occasion, my lord,
Is he the gentleman who's working now?
yes, now for the moment he's, and it is at his endeavor, my lord, that the department has started ruling.
my lord, today was fixed for examination of the judgment debtor. My lord, since there is no stay on the award order 34 in the eye of law, which is dismissed for default long time back, I would be humbly beseeching, my lord, to allow me to examine him. Because that's what the law provides.
The affidavit of asset and all has been filed.
Have been filed disclosing only, my lord, bank accounts. Immovable properties, my lord, have not been disclosed.
He can put few questions.
My lord, that would, my lord, amount to the proceeding, the execution application, my lord.
All right.
Your lordship
Okay,
will
we'll
kindly
have it after
consider my
6
prayer.
weeks. All right. The
ওনার নামটা লিখে দিতে বলেন নামটা কি নামটা
mark the appearance of
ও দিয়ে দিচ্ছে
the Executive Director, Public Health Department is present in the court. Full stop. List the matter on giver after 6 weeks.
My lord,
Please ensure it is done.
Yes, my lord.
The reason of calling you is to apprise you is to apprise you of the situation. Look at what has been done. Such a huge amount of public money being wasted just because you are just sleeping over the entire proceedings. Nothing more. Please take it to a logical end.
My lord, would it be my lord's
After
pleasure
speaking.
to direct him to be present on the returnable date?
We'll see that.
Because
That if necessary, my lord. he would be
Necessary,
there.
I'll see that.
In the
Let them
meantime,
first.
Section 34 is to be heard out.
my
Deeply
my lord,
obliged.
one more humble prayer, not on the merits of the case. My lord, since my lord has substantially heard this matter, could it be marked part of the execution case? My lord?
To that, my lord, we agree to.
We have
Your
no
lordship,
difficulty, my lord. That's a joint prayer being made by my lord. My lord is aware of the facts of this case. If it
I'm
come
already suffering from the appellate side, you know. I've got so many matters.
I appreciate it. Obliged, deeply obliged.
You can file your wakalata.
Yes, sir. I have already said.
Or leave. Just take down. Leave is granted to the State Bank of India,
Darjeeling and Kashmir.
Darjeeling Restaurant branch, as well as the Central Bank of India to file the wakalata.
Before the department. March, quickly.
This is an execution application. Lord, post award, section 34 and 37 both have been dismissed. The award has been upheld. Now, Lord, there are certain money lying with the registrar. The lordships will see it from prayer A and B of the tabular statement. These are the money which is lying with the registrar, Lord. One in the form of a bank guarantee, which is expiring on 14th of January.
Yes.
Lord, I am seeking, Lord, release of this fund A and B with immediate effect. And Lord, I am also praying in terms of prayer E for calling for an affidavit of assets.
Yes.
My lord, I appear for the judgment debtor. My lord, what my learned friend says about the amounts which are lying is absolutely true. My lord, 10 crores and odd was deposited by way of security in cash with the registrar.
Yes.
And another bank guarantee of 10 crores and odd was given, my lord, as and by way of bank guarantee. My lord, I should be frank, my lord. DVC, my lord, who is the judgment debtor before your lordship, needs just a little more time for two reasons. My lord, I have had a word with them. They are trying either to file an SLP, which time has perhaps expired, but they want to take a chance, or they say that they will all pay up the entire money, my lord, which is lying with them. So far as the affidavit of assets is concerned, that will come later on. Well, for the moment, my lord, I was humbly praying, kindly adjourn the matter till 30th of January. Well, in the meantime, I shall keep the bank guarantee, which is due to expire on the 14th of January. I shall keep it renewed. And on the 30th of January, if I don't succeed either to get a stay order, well, the money will automatically go to them. But I'm just praying,
That
my
is
lord.
not the purport of the execution petition, sir. You know it.
It is true. It is true. But my lord, they just need a little time, my lord, to see if they can go to
You already had so much time. If you actually look at it,
no,
the first year APCOM got dismissed on 13/8/2024.
15th December, my lord. 5th
Then-
December. 5th December.
37. That is section
That is
37.
Yes.
So 34 got dismissed on 13/8, and then your 37
Yes,
got dismissed
and
on
pursuant
5th
to
of
the order,
December.
pursuant to an order passed in the section 36 application, my lord, these large sums, more than 20 crores, have been deposited. For all practical purposes, as I see it, it is already there.
Why should he suffer for the laxity on part
Well,
of the government?
I just, my lord, that is my prayer before your lordship, because so far as the interest amount is concerned, which he says, none of the properties are within jurisdiction, but I will not stand in the way, my lord, of my learned friend getting the money, but I was only praying for the 30th January, my lord, window.
Lord, release the money, Lord. We'll hold the money, Lord, in a fixed deposit account.
Well,
And we will submit, Lord,
How will that help you?
Lord, because, Lord, at least my client will see the color of the money. Because, Lord, the point is today that the bank guarantee expires on 14th of January.
We'll keep it renewed.
No, Lord, the point is, Lord, if
And the claim
keeping it
period is
renewed, Lord,
27.
doesn't help my client.
27.
Lord, we have been contesting this litigation from 2019. This 21 is the award. Lord, for a period of 4 years, my client has been fighting, Lord, both in before the arbitrator as well as before the courts. So, Lord, kindly, Lord, today, Lord, there is no reason, Lord, to withhold, Lord, at least, Lord, grant of prayer A and B before your Lordship. And then we have succeeded before 3 forums, the arbitrator, Lord, the section 34 and section 37. So, Lord, there is no issue, Lord, of not releasing the funds. Your Lordships may kindly, Lord, pass an order in terms of prayer A and B. At least, Lord, B, Lord, let the registrar, Lord, invoke the bank guarantee and keep it with him.
Well, so far as the claim period in the bank guarantee is concerned, it is still 2027. But I'm not making that an issue. I'm making it very clear, my lord, the bank guarantee, which is due to expire on the 14th, will be kept renewed. Kindly give me this time till 30th. He will get his money on the 30th if he don't succeed otherwise.
These days, the line of judgments which are coming from the Supreme Court, have you seen for the execution matters?
Yes. I've seen. But I'm making that prayer, my lord. I leave it to my lord. Because besides that...
Lord, kindly do not grant time. Lord, enough time has been given.
At least 2
kindly do not grant time. Lord, kindly, Lord...
They are not in a position to take the decision.
Lord, before the 37 court, Lord, I just want to point out, before the 37 court, they had...
Do you think in 2 weeks' time they can do something?
No, Lord, I don't think so, number one. Number two, Lord, I just wanted to point out,
what they'll do is, I'll tell you what they'll do. They'll file an SLP, they'll come up with a SLP number. It will not even be listed.
Yes.
Lord,
but I will not stay this at all. But
absolutely.
Lord, the other thing, Lord, I just wanted to point out, before the 37 court, they, Lord, restricted their challenge to a loss of profit, Lord, of 7 crores, which was allowed by the arbitrator. That's all. The rest of the claim of 30 crores, which is now 30 crores, was not at all challenged. So, Lord, let me, Lord, have a portion of the money at least.
Yes.
Well, did it initially been filed?
Then I should release it. If you yourself are admitting,
well, I tell your lordship, just give me this last.
They should have a portion of this.
Just give me this last chance, because
the only
they might
difficulty is
even, my lord, the DVC authorities, my lord, I have been instructed to submit to your lordship, are even considering whether, my lord, the entire money should be paid off. But it is lying, it's about 10 lakhs and odd which would be left unpaid. But the entire amount which has been given as in by way of bank guarantee and as in by way of cash with the registrar is lying secured. It's a question of getting it tomorrow or after a fortnight.
So at least they should get some bit of it.
Well, it's just these...
The rest you can pay later.
My learned friend will not stand in the way. I will request him. He will get his entire thing within 14 days. Because
Lord, kindly, Lord, I can't, Lord, agree to this because
he's standing in the way.
Enormous pressure from the client, Lord. I just can't agree.
I am not asking him to agree. I'm requesting your lordship, my lord, to make him agree and wait for this fortnight.
The judgment debtor.
Let's face it, my lord, 10 crores, 55 lakhs and odd is bank guarantees there, and 10 crores, 55 lakhs and odd is lying with the registrar. He will get that money. It's a question of a fortnight, or I ask for the 30th. My lord can abridge the time also if my lord so pleases.
Kindly, Lord, do not grant time. At least, Lord, for the timing, this is part of the claim.
Then everything goes. Supposing, my lord, supposing. Of course, this is, my lord, an exercise in futility. I know that for myself as a lawyer. My lord, the SLP, even if it is filed, it will never be heard in the course of a fortnight. So, my lord, let him wait for a fortnight. I will keep the bank guarantee renewed, and then let him...
How does that help? It doesn't help me. As an executing court, that is of no help to me.
Well, I'm
you know the kind of...
Well, that is, my lord, then in that case, do not say anything. I just pass a direction that I shall keep the bank guarantee renewed and simply adjourn the matter till a particular date. And then, my lord, as item number 1, he will get his money. I have, in fact, advised my clients to pay the entire amount. If they have not succeeded before 3 fora, I see no reason why they will succeed. But all this is not to be quoted or noted as my submissions. I have advised them to pay off.
Lord, I can concede to this. Lord, let the money come to my hand. I will keep it in a fixed deposit for a fortnight. In terms of your lordship's order, I'll deposit the fixed deposit receipt, Lord, in court.
Well,
or before the registrar, if your lordship wants, I can give my learned friend a copy.
That doesn't really help, Mr.
Lord, the point is that, Lord, he wants to keep the money in his pocket till he has filed the SLP. This is the prayer before the court.
Money is
Lord,
with
kindly
the registrar.
Is with the registrar,
money with the registrar, but Lord, it's
not in his pocket.
Lord, it is not in my pocket either.
That's right.
That, and he is enjoying, Lord, not
Not in
giving me
my
the
pocket
money, which
either.
is the
It is
fruits
not
of
in
the
my pocket
arbitration.
either.
Lord, therefore, Lord, today, Lord, the situation is that there is nothing which prevents your lordship from directing release of the money.
Nothing prevents. All right.
Kindly give me a little time, my lord. It'll be done. It'll be done.
Sir, you have already taken a lot of time. If you succeed in the SLP, you succeed
Well,
in
the last order by which the application under setting aside the award was disposed of is 5th
5th of
December
December.
2025.
Fifth.
And my lord, they had initially moved the executing court in Alipur. They have withdrawn that amount after this money was put in. So, my lord, in 14 days.
No money was withdrawn.
No. It was the execution.
Because Section
application which was
34
withdrawn.
stay was granted. Therefore, we had to withdraw the
Right.
application. We couldn't
But
do
all that
anything.
I'm submitting is let my learned friend not see the color of money in his own pocket just for a period of fortnight. Give me a chance. Either we pay off the entire amount.
As an executing court, I should, if there's nothing which is there which actually holds me.
Well, then I leave it to my lord. But I don't think, my lord, a fortnight would really make the heavens
If
fall. for
Mr.
my
Carr
learned
would have
friend.
been more obliging,
Lord, look at this.
I would have.
This gentleman, Lord, 2000, from 2017, he has been fighting. 19, the reference was there. And
I
then, Lord, the
realize
award.
his client is a gentleman. My lord, DVC is also
in
not going
2
to
weeks'
run away with
time,
the
you'll
money.
get the entire money.
Lord,
Mr.
the issue is not of 2 weeks. Lord, issue is, Lord, further prolongation. Tomorrow, Lord, they will come and say that I have filed, Lord, this is the diary number. Give me 2 more weeks time.
That
Lord,
doesn't.
That will
kindly,
not help.
kindly, Lord,
I will not at least come and say that.
kindly, Lord, protect my client because they want this money. This is their hardened, Lord, situation which they have succeeded
All right,
before
take note.
3-4.
The judgment holder has preferred the present execution, seeking enforcement of the arbitral award dated 14/8/2021. Full stop. Learned senior counsel for the award holder submits that the judgment debtor had challenged the said arbitral award before the court in APCOM 231, right? 231 of 2024,
Page 56, your lordship will
which
get.
came to be dismissed by order dated 13/8/2024. Full stop. Thereafter,
Page
the
77 is.
judgment debtor preferred an appeal under Section 37 of the Arbitration and Conciliation Act 1996, being APOT 379 of 2024, challenging the order dated 13/8/2024. Full stop. The said challenge, stood dismissed by order dated 5/12/2025. Full stop. In view thereof, the arbitral award dated 14/8/2021 has attained finality, and the present execution petition has been filed for implementation thereof. Full stop. Learned counsel for the award holder submits that the total awarded amount of rupees 259,821,464.58 that the total awarded amount is rupees so and so. Full stop. It is further submitted that pursuant to the directions passed by this court, the judgment debtor had deposited an amount of rupees 1,055,17047 in the name of registrar original side, and
the bank guarantee of the same amount.
And has also furnished a bank guarantee for a further sum of rupees 1,055,17047. Full stop. Accordingly, learned senior counsel for the award holder makes a prayer for release of the deposited amount and encashment of the bank guarantee in favor of the judgment holder. Full stop. Learned counsel for the judgment debtor states that the award has attained finality, though they are considering considering filing of a special leave petition. Full stop. As on date, no SLP has been preferred. Full stop. This court has heard the submission advanced by the counsel for the parties. Full stop. In view of the above submission and considering that the arbitral award has attained finality, prayer A and B of the present execution petition are allowed. Full stop. The registrar original side is directed to encash the fixed deposit as referred to in prayer A and release the same to the authorized representative of the judgment holder. Full stop. The bank guarantee referred to in prayer B shall be encashed and the proceeds thereof shall be released to the authorized representative of the judgment holder. Full stop. Upon realization of the aforesaid amounts, learned counsel for the judgment holder shall file a calculation sheet indicating the balance amount, comma, if any, remaining due and payable towards the satisfaction of the arbitral award dated 14/8/2021. The judgment debtor shall file an affidavit of assets within a period of how much time?
Well, at least a fortnight.
Within 2 weeks from date. List the matter on after 4 weeks.
I'm formally praying for a stay of this order, my lord.
Stay of this order.
Yes,
I'm
where
opposing
payment
this.
is being directed to be made to them. Well, not for anything else, but because my client is DVC, I do not want to be accused of not having.
But just one correction,
Yes.
that appeal number, your lordship will,
APOT.
your lordship will get it at page 77.
I got
It
it
was
from the-
renumbered
Achha,
as,
all right. APOT number page 77. Huh?
so this was renumbered, not
Renumber. Okay,
page
I got it from the body.
page 77. This was the finally renumbered.
AOCOM 1 of
Yes,
2025.
it's commercial. So, my lord, it's first
It's
it's numbered.
APOT chhod do. AOCOM 1 of 2025
That's
with APCOM 231 of 2025. 231 2020. Yeah, page 77.
Okay.
Well, the stay aspect, if it could at least be refuse it.
Much okay.
Grateful, my lord.
साढ़े 12 साढ़े 12
अच्छा
My lord, I am led by.
I appear for the petitioner, my lord. It's a section 29A application. My lord, the Honorable Court was pleased to appoint, my lord, on 1st of July 2024, the arbitral tribunal. Now, my lord, this is a matter in which the statement of claim was filed on 27th of November 2024. And, my lord, even after making a publication, the respondents have never turned up. So, my lord, it was, my lord, put to the ex parte board by the arbitral tribunal and proceeded with till now. And therefore, my lord, the 1 year time, my lord, expired on 27th of November 2025.
Yes.
And we are at the stage of final arguments, my lord. So, my lord, accordingly, lordship would extend the time.
Take down. The petitioner has preferred the present petition under section 29A of the Arbitration and Conciliation Act 1996 seeking extension of the mandate of the arbitral tribunal for concluding its proceedings and publication of the award. Full stop. Learned counsel for the petitioner, Mr. Banerjee, submits that this court, by order dated 1/7/2024, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The statement of claim was filed on 27/11/2024. Full stop. There was no appearance on behalf of the respondent despite service, and hence the respondent was proceeded ex parte. Full stop. The mandate of the arbitral tribunal expired on 27/11/2025. Full stop. The matter is at the stage of final argument. Full stop. In view thereof, comma, the learned counsel for the petitioner prays for extension of the mandate. Full stop. How many sittings have been held, Mr. Banerjee?
My lord, the last sitting, if I may see, my lord, is the 9th sitting only, my lord.
The arbitral tribunal has held 9 sittings and recorded claimant's evidence. Full stop. The respondent remained absent throughout. Full stop. Now the matter is at the final argument stage. Upon consideration of the materials on record, this court is satisfied that no undue delay is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the proceeding and in the interest of justice, comma, the mandate of the arbitral tribunal is extended further for a period of 6 months from today. Full stop. The learned sole arbitrator is requested to make all reasonable endeavors to conclude the arbitral proceedings and publish the award within the extended time period. Full stop. With the aforesaid observation, the present petition stands disposed of.
Grateful, my lord, deeply obliged.
Eight, my lord, I appear for the petitioner. This is my application under section 29A, praying for extension of mandate of the substitute arbitrator. Now, lordship, if I may just indicate the facts in brief.
Yes.
The initial arbitrator was appointed by an order dated 13th of April 2023. The pleadings were completed on 9th of August 2023, and the 1-year period expired on 8th of August 2024. The mandate expired. We took out an application under section 29A. During the pendency of my section 29A, the arbitrator was elevated as an honorable judge of this honorable court. So the entire scenario went within the 4 corners of section 14.
Yeah.
We took out an application under section 14 read with section 11, which was allowed by this honorable court on May 2025 of this year. Substitute on July 2025 of this year, and the substitute arbitrator was appointed. The first sitting was held. The substitute arbitrator was of the view that because the mandate was not extended, appropriate directions may be sought for before the honorable court. So, my lord, my humble prayer is that the mandate may be extended because under the section 29A. That is my only prayer.
I'm for the respondent.
You don't have any objection to it? Take down. The petitioner has preferred the present petition under section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal for concluding the
May I just
proceeding,
interject one?
application of the award.
The 6 months, they did not consent to the extension of 6 months as envisaged under 29A3. So that was not done. They had not consented, which compelled me to go before the honorable court for under 29A.
Learned counsel for the, what's your name?
My lord, my name is my name Devjani Sengupta, my lord.
Miss Learned counsel for the petitioner, Miss Devjani Sengupta, submits that this court-wide order dated 13/4/2025 appointed sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 9/8/2023. Full stop. Though the petitioner consented to the extension of the mandate of the arbitral tribunal, the respondent objected thereto, comma, and consequently, comma, the mandate of the arbitral tribunal expired on 8/8/2024. Full stop. It is further submitted that the learned sole arbitrator was thereafter elevated as a judge of this court. Full stop. In view thereof, comma, this court, by a subsequent order dated, what is the date of the order?
30th of July 2025.
30th of July 2025, appointed a substitute sole arbitrator. Full stop. The newly appointed sole arbitrator held the first sitting on 25/9, right? 25/9/2025, and observed that since the mandate of the earlier tribunal had expired, extension of the mandate under Section 29A4 of the Act was required for proceeding further with the proceeding. Full stop. In the aforesaid circumstances, the petitioner has preferred the present petition. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the materials placed on record, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator. Full stop. The arbitral tribunal has been reconstituted by this court, and the proceedings presently being at the stage of evidence, the tribunal is required to proceed further. Having regard to the stage of the proceedings, and in the interest of justice, the mandate of the learned sole arbitrator is extended further for a period of 1 year.
1 year.
1 year from today, the learned sole arbitrator is requested to make all reasonable endeavors to conclude the proceedings and publish the award within the extended time period. Full stop. With the aforesaid observation, the present petition is disposed of.
I'm deeply obliged, my lord.
I am filing my Wakalatnama.
Wakalatnama is taken on record.
Well, this is again my section 29 application. The facts are little similar, absolutely, my lord, with the item number 7. My lord, the arbitrator was appointed by an order of this court on 3rd of October, my lord, 2024. And my lord, on 3rd of December 2024, we had filed a statement of claim. But thereafter, giving ample opportunity, and even after publication, my lord, since the respondent did not appear, so my lord, and the learned arbitral tribunal was pleased to fix it ex parte. And my lord, on 2nd of December 2025, my lord, the mandate had expired, my lord, 1 year from the time when I filed my statement of claim. My lord.
How many hearings?
9
My
years.
lord, here also 9 hearings, my lord, 9 sittings, my lord.
ये item 7 है ना, उसमें बस changes करो. Date of appointment 3/10/2024. Alright. Completion of pleading 3/12/2024. Expiration of mandate 2/12/2024. Rest same.
Grateful, my lord.
2/12/2024. Mandate, huh? ठीक है? Only 3 dates will change.
Yes, my lord. Grateful, my lord.
Much of.
My application under section 29A, my lord. The learned arbitrator was appointed by an order dated 28th February 2024 that was communicated to the learned arbitrator on 4th March 2024.
Have you served the other side?
I've served, my lord. The affidavit of service is on record, my lord, I'm told.
When was the arbitrator appointed?
At 28th February 2024, it was communicated on 4th March 2024, my lord. Pleadings were completed by 20th June 2024, my lord. And the mandate was supposed to expire 1 year later, but on that particular date, it was extended by consent of the parties. That is recorded in the minutes dated 24th June 2025, my lord. Page 31 of my brief, my lord, of my lord's brief, my lord. And in my humble submission, thereafter 1 year have gone by. There have been 3 witnesses of the.
So the mandate expires on
31st December, my lord. You have filed it before expiration of the mandate.
Now it doesn't matter.
That of course.
How many hearings?
27 sittings have been held. 4 witnesses have been examined and cross-examined. The final arguments are supposed to commence, my lord.
Stage of unlock.
My lord.
All right. The petitioner has preferred the present same word also. Learned counsel for the petitioner submits that this court-wide order dated 28/2, right? 28/2.
My lord.
28/2/2024 appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. He states that the pleadings were completed on 26/2024. Full stop. He further states that with the consent of the parties, the mandate of the arbitral tribunal was extended by 6 months. Full stop. Now the mandate is expiring on 31/12/2025. Full stop. In view thereof, the petitioner prays for extension of the mandate. Full stop. He further states that the arbitral tribunal had held 24 hearings and the matter is at the stage of final arguments. Full stop. Upon consideration of the materials on record, this court is satisfied that no delay is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the proceeding and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of how much time?
6 months. 6 months, my lord, subject to your lordships.
6 months?
Right.
6 months. 6 months from today. Full stop. The learned sole arbitrator is requested to make all reasonable endeavors to conclude the proceedings and publish the award within the extended time period. With the aforesaid observation, the present petition stands disposed of.
Deeply. But my application, my appeal under section 37, my lord, on the last occasion also the respondents did not appear. Completely unreasoned order. Section 21 notice not issued. Statement of claim not served. Section 17 not served. Merely the order has been served. Arbitration agreement according to us does not exist. Merely the order was served. Even thereafter, we were not given any notice of the arbitral proceedings. We do not know the stage of the arbitral proceedings. And the order is at page 15, my lord, is the order.
Is the communication.
Communication of the order.
Last time did they appear?
They did not appear.
No. Last time
Have they appeared?
it was taken up and a stay was done.
Yesterday it was taken up. They did not appear. On the first day when the matter was taken up, they did not appear. And ex parte, the order was passed of staying the operation of the impugned order. Honorable Coordinate Bench, Honorable Justice Shubhushachi Bhattacharya had passed that order.
আমরা অ্যাডভোকেট তো সার্ভিস করেছি, অ্যাডভোকেট রিসিভ করেছে, তারপরেও আছে দিস পার্টিকুলার না। এই যে বিশ্বজিৎ মিত্রকেও আমরা জানিয়েছি।
Which is the order?
Page 15, my lord. Page 15, it starts page 16 onwards.
No,
Page
15 we got to know from the bank. We were not aware.
We were,
That
page 15 is a communication order. That too not from the learned arbitrator. We got to know from the bank.
that a bank has been attached.
Page 16 is the order. The order says attachment of my bank account. I get to know from the bank, not from the arbitrator, not from the respondent.
This is not the order. This is communication of the order by the advocate. Order starts from 9.
Page 19 is also there. Page 16, the order is typed on the letterhead of the learned advocate of the respondent. Page 19 is the order. This is signed by the purported learned arbitrator.
Honorable, for safety, we will serve him once again. Then next week, let the matter be taken up. We'll do it.
যদি হয়ে যায় কতবার সার্ভ করবো তো করেছি আসছে না
The proceedings are going on.
proceedings we are not given the notice of the proceedings. We do not we have
After this order, nothing has been done.
nothing we have not been communicated anything. We have we have served the learned arbitrator
And the advocate, Biswajit.
The arbitral proceedings must be going on.
arbitral proceedings. My lord will kindly come to page 23. We have served this notice upon the sole arbitrator. No reply, no nothing.
Serve the other side. We'll have it on Tuesday.
I'll serve the learned
Get that
advocate.
inside. There's nothing in here.
Bishwajit Mitra has communicated. Let me serve Mr. Bishwajit Mitra learned
Serve him.
advocate.
We'll have it on Tuesday. If they don't come, we'll pass it on.
Order করে দিতে বলুন না, তাহলে we'll serve the order.
If a order can be passed, we'll serve it along with the order.
None appears for the respondent. Learned counsel for the petitioner shall serve upon the respondent. List it on Tuesday.
Deep.
Parents shall last week দিয়ে দেবে।
But my appeal under section 37, this is in regard to the section 17 was for police help for implementation of an order by which a receiver was appointed to take physical possession of a property, my lord. The receiver could not take possession, so we made an application for police help. That application has not been disposed of, but at the ad interim stage, no order was passed. That is why I'm before your lordship, my lord. The only thing, my lord, thereafter a development has taken place. I had to, if my lord deems fit, may I file a supplementary affidavit. This is a subsequent development because what had happened in respect of this arbitration, there was a section 9 and the order by this honorable court that was violated by the respondents. In spite of an order, properties were sold off. A contempt proceedings was initiated. In the contempt proceedings, the respondents was found to be guilty of contempt. So they have not been sent to jail, but they have been told to do community service, which has also not been done. That is also pending. In the meantime, since some of the properties have already been sold, the respondents was told to disclose by way of an affidavit the properties which are not yet sold. They had given an affidavit which according to them listed out the properties which were not yet sold by them. I made an application under section 17 for appointing a receiver to take physical possession of those properties so that those properties cannot also be sold out. That was granted. I took out an application for police help. The urgency was that since they have already sold off and since they were the honorable court had already hauled them up for contempt, they might sell off all those 4 properties as well. That is why the
order has already been passed for appointment of the receiver and
receiver has been passed, my lord. The police help application at the ad interim stage order was not passed, but my lord, in my humble submission thereafter, the development what happened was that they come and say that in those affidavit the details of the property they had given the details are wrong, details are not right.
That's in the execution proceedings.
That is in the police help application. After I filed this appeal, on the next day they come up and say the particulars are not right. So these are not the properties. The properties are different.
Then there's no point of getting the police help.
The only thing, the receiver actually went to this property. They did not cooperate, for which they did not take.
But today the scenario has changed. The scenario has changed. Those properties are not with the.
But the only thing, this is, my lord knows that this is a dilatory tactics. The moment the receiver goes, I do not give possession, and then thereafter come to the arbitrator and say the properties are, this is not, these are not the properties. The properties are other properties. Thereafter.
But today I can't pass an order for police help.
That is the only difficulty, and this will repeat again and again and again. That is the only difficulty.
Whatever it is, I can't pass an order for the police help today. The scenario has changed.
The only thing I'm under instructions that the advocate on record actually accompanied the receiver. The properties were there. It was only due to the non-cooperation of the respondent he could not take physical possession.
Receiver can come to the court and ask for police help. There's no point doing anything right now. What do you want to do with this application?
I'll serve again and come back, my lord, in that case. The supplementary affidavit may be taken on record.
There's no point.
As my lord deems.
Learned counsel for the petitioner. Praise for a short adjournment. Let this.
My affidavit of service may be taken on.
Affidavit of service taken on record. Counsel for the petitioner seeks an adjournment. Let this matter be adjourned for 4 weeks.
Well, this is my section 37 appeal from an order passed under section 17 of the Arbitration Act. Very briefly, my lord, I am Eastern Coalfields Limited. My lord, there is a contract with the respondent, who is the claimant in the reference for reviving of a power plant, for revival of a power plant, and also for then transmission of electricity. My lord, so this contemplates phase-wise setting up, and also once it is set up, we are to supply coal as per a lease agreement thereafter entered into between us, by which ECL leases its plant to the claimant at a lease rent of some 4.54 crores per annum. That is from 2018. Now, what happened thereafter is that they wanted to do a trial run. And in the trial run, they wanted coal supply. Coal could not be supplied. The claimant responded, files a writ petition, where we take the point of this being really a specific performance of an agreement, but that the court, our High Court, says nothing doing. You supply the coal. And so that, because they were wanting the coal for the trial run, and thereafter, without the trial run, the next stage could not come. So this was the writ petition allowed, appeal by Coal India as also by Eastern Coalfields dismissed. No, coal has to be supplied. Thereafter, up to Supreme Court dismissed. Then what they do, instead of executing this mandamus order, they go to arbitration, where they make a claim for specific performances a second time around, and also damages in case specific performance can't be had. As in, if we cannot supply them coal, we should give them compensation. To this, our defense is that you are aware there's a government policy by which coal supply, linkage basis is not possible. This is there from 2012. To that, their answer is, but there's a mandamus of the court. To that, our answer is, if there's a mandamus, you file execution. Be that as it may, that's in the arbitration. In the arbitration, there's their claim for specific performance, as also this part. Now, we make a counter claim for the rent which they are anyways liable to pay. We may, evidence over, argument starts. At the argument stage, one day it is submitted by the claimant and recorded in the minutes of the meeting that they are no longer pressing for specific performance and they want to claim money claim. because coal cannot be had under government policy. You can't get blood out of stone. Be that as it may, so they are now claiming money. At this, my lord, we make a Section 17 application that if it's a money claim, you then hand over this plant which you are holding on to, lying locked up, and we can put it to use. After all, this is a public coal company, and anyways, otherwise you pay the lease rent which you are liable to pay. You just can't go on occupying this plant of mine and neither pay any money nor not maintaining it. And they also said that they have stopped maintaining the plant. This is also recorded in the evidence of their managing director. We filed, they give it back to me. Alternatively, pay the lease rent. Their defense was, you didn't make a counterclaim for recovery of possession. If the specific performance fails, automatically they have no right to retain this plant, because this is in furtherance of performance of the agreement by running the plant, reviving and running the plant. He's had for revival of the plant, we had given them, I think, 25 odd crores. For revival. 25 or some crores. But of course, they are saying they've spent more than that. But that's a money claim. Now, my lord, the learned arbitrator rejected our application, essentially that, Lordship, may I come straight away to the impugned order before I come to the documents? Yes. That from page 7 of the impugned order, last 2 lines. Going through the application filed under Section 17 of the Arbitration Act, it appears that the respondent applicant filed the interim application at this stage of the proceeding in view of the submissions of the learned senior counsel for the claimant, as recorded in the recorded submissions of 43rd sitting, wherein, according to the respondent applicant, the claimant had expressly abandoned the ITS claim for specific performance. Paragraph 9 of the said interim application is set out below. In light of the foregoing facts, circumstances, the petitioner filed the present application since they were abandoned. I will show the minutes also. In next paragraph, in course of argument, the learned senior counsel for the claimant repeatedly submitted that the claimant never expressly abandoned its claim for specific performance of the contract. Going through the recorded submissions of the learned senior counsel for the claimant, it appears that the learned senior counsel categorically submitted at the present stage specific performance of the contract would not be possible because of the stand of the respondent, especially due to non-supply of coal out by the respondent. The submission of the learned senior counsel should be taken into consideration in its entirety. Any scattered and or distorted part of the recorded submission cannot give the actual meaning and or intention arising out of the submissions made by the learned senior counsel on behalf of his client. In the present case, also the learned senior counsel of the claimant never expressly abandoned the claim for specific performance, and in course of argument, categorically submitted at this present stage, at the argument stage, specific performance of the contract would not be possible because of the stand of the respondent and due to non-supply of coal. Therefore, no circumstance can be said that the claimant had abandoned. Furthermore, if the interim application is filed on the basis of and upon referring to any part or portion of submission of any counsel and the witness, then it would be very difficult to effectively decide an arbitration proceeding finally. In the present reference, the interim application has been filed at the very last stage, when the main arbitration proceeding was almost nearing completion. The award could have been passed if the present interim application was not required to be decided at this stage. Scrutinizing the present application filed under Section 17, it appears that no important issue was raised in the present interim application for consideration. Also, not the case of the respondent that any important issue arose suddenly in course of argument. The senior counsel respondent filed the interim application only on 2 grounds. The claimant has expressly given up its claim for specific performance, which is not at all acceptable to this tribunal for the reasons the claimant was not maintaining the plant since September 2022, which according to the claim was on account of the breach on the part of the respondent applicant, although for a considerable period of 3 years, the claimant had maintained the plant. As stated earlier, the respondent applicant should not take out any part or portion of the submission of the learned senior counsel for the claimant in relation to specific performance and ignore the rest of the submissions. In my opinion, the submission of the claimant should be considered in its entirety. Respondent applicant made no claim for possession of the plant and machinery in its counterclaim, and the reliefs claimed in the counterclaim is only for rent. In the absence of claim in relation to any final relief for possession, there is no question of granting any interim relief for handing over of possession of the plant and machinery to the respondent applicant. This tribunal also cannot be unmindful of the issues whether the said lease rent would be payable by the claimant even after non-supply of coal and water by the respondent. This tribunal cannot examine and decide any issue, especially with regard to the obligation of the respondent under the agreement regarding supply of coal and water in this application. The relief claimed on behalf of the respondent for rent, in fact, supports the continuance of the possession of the plant with the claimant as has been claimed by the learned senior counsel for the claimant. It is not the case of the respondent that it had terminated the lease agreement and also did not submit that the respondent would give up their counterclaim with regard to rent. Of course, I'll give it up if they pay the rent. Therefore, in absence of any final relief for possession claimed in the counterclaim, there would be no scope for granting any interim relief for handing over of possession. Claimant had claimed that it had incurred expenses for the plant and machinery. In the aforesaid circumstances, any decision on that issue as to whether the claimant had spent any money at all, I'm not at all for maintaining the plant and machinery should be avoided at this stage. No one is asking for that, the determination. According to this tribunal, there could be no dispute regarding payment of lease rent by the claimant. But the real issue, which should be decided finally by this tribunal, is whether such lease rent would be payable even without supply of coal and water by the respondent. A aforesaid issue is to be decided finally while deciding the main arbitration. Arbitral tribunal finds that any decision with regard to this would be a final decision as to whether or not the respondent applicant would be entitled to rent in spite of breach of the contract on the part of the respondent. Furthermore, there had never been any demand for payment of rent since 2019. The relief as claimed in the interim application filed under Section 17 would virtually go beyond the main issues raised in the main arbitration proceeding, and therefore it would be beyond the jurisdiction of the present arbitral reference, as has been correctly submitted. Now, Lordship, may I show my Lord a few admitted...
This is entirely on the fact that you have given up the relief of...
My Lord, two ways.
Statement.
My Lord, there are two ways. One is giving up the relief of specific performance. Then they can't retain the plant. Second part, alternatively, even otherwise, if they claim specific performance, I've cited judgments on the proposition, they can't hold on to the property and not pay the rent. Because the rent is payable as per the lease agreement. And it is not linked to anything else.
The arbitrary records, you have not sought for the rent.
Yes, that is my counterclaim. No, that's possibly factually wrong. Because that's my specific counterclaim. So they can't have it both ways. So Lordship kindly comes. So আমাকে show me the SOC prayers and the counterclaim. Now Lordship kindly comes to the lease agreement first. Where is the lease agreement? Page 392, na? 392. Which is part of their statement of claim. Rent is? 390. Lordship kindly comes to the lease agreement. There's a typed copy follows each page. Lordship kindly comes to the relevant part. The page 394, capital A.
Yes.
It is hereby agreed by between the parties as follows. in consideration of the rent hereby reserved and of the covenants, clause 1.1, covenants, conditions, and agreements hereinafter contained and on the part of the lessee to be paid, observed, and performed. The lessor doth hereby grant and demise up to the lessee all that the land fully described in the schedule. Buildings described in the second schedule. To hold the same, the seventh or eighth, to hold the same on the terms on the same lease for a term of 20 years, commencing from the date of signing of this agreement and paying, therefore, save the lesser the monthly rent as stipulated in 4.0 below on or before 7th day of each month. Now, Lordship kindly comes to page the 397, capital A is the rent.
This is executed on?
My lord.
The date of this.
This lease agreement date is, the date bolo? 7th August 2019. 7th August 2019. Now, for the SSA will be future executed for the coal supply. It's mentioned in the lease deed. Now kindly come to 397 capital A. Clause 3.1.
398, huh?
390, yes. 397 capital A. And Lordship, so far as supply of coal is concerned, that is, Lordship, which is clause, which is at page 400 capital A.
First, you're showing me lease rent, right?
Lease rent, that is 397.
397.
That is the amount is mentioned. 3.1.
Yes. Then what are you showing me?
Then I am showing, since there is reference to coal supply, whether it's linked.
Yes.
400 capital. Fuel clause 7.1.
Yes.
I don't know whether my learned friend is arguing the entire section 17 or not. But, my lord, because I'm a little surprised, my lord, at the way, my lord, he's proceeded with the argument. Should have just told my lord first.
Tell me how to argue, Mr. Banerjee.
So what's the interim?
Tell me what.
No, I mean, what are we asking? Are you asking for an ad interim order now?
I'm asking for my lord to hear the matter and decide it.
Then, my lord, either, my lord, I file, my lord, put everything on record, because he's not put everything on record, and I'm surprised, my lord, at the argument. He should have, my lord, first told my lord that what has happened with regard to the why, my lord, the plant is with us and why the plant is non-functional. My lord,
yes,
that is. You will put that. You will put that. I'm sure.
If my lord is at all entertaining this appeal, my lord, I would like to file an affidavit. If at all, my lord, this appeal is being entertained, because my lord, 4 years.
Appeal will be entertained. Reply has to be filed in the sense, I have to hear both the sides, then I'll decide.
Then, my lord, I'll file reply, my lord.
Let him make his submissions. Then we'll see.
Page 400, capital A, clause 7.1.
Yes.
Fuel G5 and G6 grade of coal will be supplied at notified price by BCL at 50-50 ratio. There's some more clauses. 50-50 ratio through execution of a FSA, fuel supply agreement, MOL, whatever, applicable coal supply agreement with ECL. So there'll be a future agreement for supply of coal. That is, coal will be supplied from new bimines within 40 radius from the plant. Let's say we'll make his own arrangement. So coal supply, there'll be a future agreement. They will pay the price of coal. I will supply the coal, if that's possible.
See, what I can understand from the order, section 17 order, is to the extent that you were asking for possession of the plant. The learned arbitrator has decided it against you on the basis that the entire appeal, the entire arbitration proceedings, the dispute is different to the extent that you have your claims. You have your claim counterclaim, both are there. That has to be decided. Just because a mere statement has been made by him that he will not be pursuing this specific performance, on that basis, you are saying that, you should take over. That is literally giving up deciding the final relief. And that is the reason why he has dismissed it.
So far as recovery of possession.
Recovery of possession is concerned.
Though I will show this categoric statement, but still let's take it that his senior counsel statement may not be taken that far.
Correct.
But so far as by occupation charges, in any in any proceeding, I've cited
So that
charges.
will be decided.
No,
Your occupation charges, other things, everything is left open.
The time, but so long as they are going on occupying, they just cannot hold on to possession without paying anything for it.
No, but that is something which, if you see the application, section 17 application, are you asking for rent in the alternate? You're not. You are asking only for the possession of the plant in view of the statement made by the claimant.
Yes, that is page.
And that is the reason why the learned arbitrator has dismissed it on the ground that the entire proceedings are yet to be adjudicated. So whether we are deciding that is.
Now, Lordship, kindly sees page 383.
383.
Independent receiver cost
383, this is my application.
Yes.
Paragraph 5.
Yes.
During the 43rd sitting of this learned tribunal held on 2nd March, the learned senior advocate appearing in behalf of the claimant submitted specific performance at contract is no longer feasible. Let me read
Where are you reading, sir?
Page 383, that is the quotation from the minutes. Or let me show from the minutes straight away, my lord. That is page 377. Lordship kindly comes to page 377.
Yes.
At 380. At 380. Last paragraph. He then places paragraph 72. 380.
Yes.
He submits that at the present stage, specific performance is not possible because of the stand of the respondent and because of non-supply of coal. The claimant is entitled to damage the loss of profit. He places page so and so.
That is
well, kindly read this with page 293. The previous volume, 293.
293 then.
Question?
Yes.
Question 186 to their principal witness. Kindly see these two read together. What is the present condition of the Chinakuri thermal power plant at site? Difficult to give the present condition unless complete assessment is made, as the claimant has stopped maintenance from September 2022. So, they cannot on the one hand retain the plant. Their claim for damages will remain as it is. If they get the specific performance, they will get the plant. So the plant, I will take it, I will be running it. So my plant will not disappear also. So let's take it that even if they did, as of now, this became evident in March 24, and his submission was thereafter sometime last year. So if they are not maintaining the plant, this is our property. They have said they don't want specific performance.
No, that's
that part, Lordship. May I just not? But that is just.
It's just a state.
Very well.
You would have made some statement like that too if you're arguing a matter where you say
minutes were being prepared, minutes were being circulated, and minutes were being corrected and sent back. So be that as it may, Lordship, they are not maintaining the plant. They are not using the plant. They are not paying a single farthing for the plant. And this is after all, this is a public property. This is a nationalized company. And if they get specific performance, they will go get the plant back.
But today you are in 37. My role to that extent, I'm not deciding. the dispute between the parties. I am only deciding if there is any impunity in the order which has been passed by the arbitrator. All this issue remains open. This is something which the arbitrator has to decide.
Final decision.
Final decision. So we'll only focus to the extent of what is the impunity in the order which has been passed.
Infirmity in the order, my lord, the
Yes.
obvious infirmity are two.
Yes.
I'm leaving aside the council's part.
Yes.
Lordship, the infirmity are two, which is apparently contrary to the contract. One is that non-supply of coal, because I did not supply coal, and coal supply is linked.
That also, Mr. Mitra, would go to the root cause of the dispute which is there between.
That is whether they will get specific performance, whether I'll be forced to supply coal, whether I'll be giving the damages for non-supply. But so far as the rent payment, that's but lease agreement, it is a
And probably
separate
that
agreement.
is the reason maybe the statement has been made that, today that supply is not something which can be looked into, and that is the reason why the specific performance is no longer possible.
Yes.
And that is the reason why now it is only limited to the money claim.
It's limited to the money claim.
That could be the scenario.
Yes, that is the scenario. That is the scenario.
Absolutely.
So if that is the scenario, well, let me respond to my lord's summarization. That is exactly what. So it's no longer possible. So what does it, if there's no specific performance possible? Money claim. So if retaining of the plant in question, because that being the position, retaining the plant, I ask myself, what for? Your claim is for money. You cannot run the plant because of the non-supply of coal. If you cannot run the plant, it's not possible to revive and run it. You can't retain the plant. Number one. Number two,
that is something again, that's a disputed thing which has to be adjudicated by the arbitrator. Today, even if I am with you, 100% I am with you, that the statement is taken as a gospel truth that they are not able to maintain the plant. Can I, in this proceeding, hand over the plant to you?
Hand over the
plant to you.
The plant.
Can I?
Taking in note of this development, the court can.
There is not. I am only looking into the impunity in the order, whereby if you are able to show that this whole aspect has been dealt with, and then the court has given a finding which is contrary to your lease agreement, contrary to everything, I can adjudicate. But today, can I grant you the relief which you are seeking?
Well, so far as the findings contrary to the lease agreement is concerned, that is at page 10 of the order.
Mr. Mitra, your entire application is based on the surmise that the claimant at this stage doesn't want to press for specific performance, and that is the reason why the plant should come to you.
That is the premise. So when the claimant says in course of argument that it is not a firm commitment, but this is one of the pieces of the submissions, then, my lord, I fall back on a lesser relief. So if you intend to retain the plant, give me the rent. On that, the learned judge, the learned arbitrator has gone contrary to the contract lease agreement by saying that non-supply of coal, as if supply of coal is linked with payment of lease rent. This finding at page 10 of the order, I accept. There is no formal prayer for the lease rent. I am asking for return of possession on the basis of their admission. When they say no, this is an admission which should not be held against me at this stage. So I said, very well. Then give me the lesser relief of at least giving me the monthly rent.
So that is what the arbitrator records, that since 2019.
19 is the agreement.
You have yourself not sought for it.
Well, that is my counterclaim.
Correct.
My counterclaim is there.
That is something which has to be decided.
But they should be at least depositing the money somewhere. But
Have you moved an application? Have you moved an application before the arbitrator?
No. But as a lesser relief, whether the court can grant it or not.
Unless until you move an application seeking for deposit of the rent during the pendency of your arbitral proceedings, whereby you say that now since the statement has been made, it is frustrated, they can't operate, they can't do
Or
anything.
whether,
At least
but even if they can operate,
even
whichever
if they
way,
can
either
operate,
way,
my rent should be given to me
Eh,
in terms of the lease agreement which has been
that should be
entered into,
deposited.
in terms of clause 7.1.
There's no separate application for that.
So that should be done. That should be done. And if you're aggrieved, the arbitrator is not allowing you, come to me.
But the arbitrator has decided the rent part without there being an application. The learned arbitrator has given a decision at page 10 of the order. I could have understood if the arbitrator did not decide that, because that is not your prayer in the application. But the arbitrator has gone ahead and decided it. If he has decided it, then that will then that decision comes up for consideration whether it is consonance with the agreed terms or not. And that's what I'm that will be my most humble submission, because because page 10 and 11 is entirely on rent, and it is said that page 10, the sixth line onwards, this tribunal can be unmindful of the issues whether said rent would be payable by the claimant even after non-supply of coal and water by the respondent. That is not an issue arising, Lordship, page 10.
First volume, right?
In the memo of appeal. In the memo of appeal,
yes,
page 10, the third, fourth, fifth, sixth line onwards, it goes on rent aspect.
The relief claimed on behalf of the respondent for rent,
yes,
in fact supports a right? That's the one.
This is page 10.
Page 10.
Yes. Now, Lordship, the sixth line, this tribunal, there's no question of
I think
granting.
it starts from the relief claimed on behalf of the respondent for rent, in fact, supports the continuance of the possession of the plant and the claimant, as has been claimed by the learned senior counsel for the claimant. It is not the case of the respondent that it had
Can go up three, four lines above that.
Sure.
This tribunal, the sixth line.
Yes. This tribunal cannot be unmindful.
Unmindful of the issue whether the said lease rent would be payable by the claimant even after non-supply of coal and water. This tribunal cannot examine and decide any issue, especially with regard to obligation to respond under the agreement regarding supply. That's not required to be decided, supply of coal and water. For that, there will be separate agreement. The relief claimed on behalf of the respondent for rent, in fact, supports the continuance of the possession of the plant with at least the claimant, as has been claimed by the senior counsel for the claimant. It is not the case of the respondent that it had terminated the lease agreement and also did not submit that the respondent would give up their counterclaim with regard to rent. If I get the possession, from the day I get the possession, automatically the rent will stop. Therefore, in the absence of any final relief for possession claimed in the counterclaim, very well, possession part, but rent part there is. Then the next paragraph, that's not required to be, there's no interim application for that. The claimant had claimed that it had incurred expenses for the plant and machinery. The aforesaid circumstances, any decision on that issue as to whether the claimant
You read that according to the tribunal, there would be no dispute regarding payment of lease rent by the claimant. But the real issue which would be decided finally by this tribunal is whether such lease rent would be payable
even without supply of coal.
Supply of coal or water.
So this part, whether it is in consonance of the lease agreement or not,
that has to be decided ultimately by the arbitrator. That is the entire.
According to this tribunal, there could be no dispute regarding payment of lease rent by the claimant. But the real issue, which should be decided finally by this tribunal, is whether such lease rent would be payable even without supply of coal and water. The aforesaid issue is to be decided. Well, that the agreement speaks for itself.
Nothing on rent as such.
Malad,
there's nothing on rent. The aforesaid issue is to be decided finally while deciding the main arbitration proceedings and not the present interim application, not at this stage basically. This arbitral tribunal finds that any decision with regard to this would be a final decision as to whether or not the respondent applicant would be entitled to rent in spite of the breach of the contract on the part of the said respondent applicant. Further, there had never been any demand for payment of rent since he has not really decided on your rent issue at all. That the assumption is not correct.
Oh, yes, not, but yes.
You can still, you're entitled to move an application seeking your rent part. He has not observed anything as far as the rent.
No, let's take it that I file an application tomorrow, but this will stay at me. According
That's
to
up to you. I'm not such.
Do not give Mr. Mitra any idea, my lord.
I'm
He
not
has
giving any.
anyway, my lord, very fertile mind, my lord.
According
Very fertile mind. The arbitration is to end. In the end, before the arbitration ended, my lord, he filed this section 17 and says, give me possession.
Let's see the date between his submission and the application. Within a month of that submission,
The advantage of having Mr. Mitra here, he can always come up with.
Oh yes, my lord. Yes, that my lord, I have seen him.
I have seen him.
Quite
I've seen
some
him
time. I want
for a very short time here in the squad, but it's always a pleasure.
I have grown up
there was
with his
no time.
my lord, also, my lord, in the
The
profession.
day he made that submission, minutes was circulated. Immediately thereafter, we made the application. But my lordship kindly sees that the last three lines. So if I make an application tomorrow, whether that right is there, according to this tribunal, there could be no dispute regarding payment of rent by the claimant. But the real issue, which should be decided finally, is whether such lease rent would be payable even without supply of coal. But when the agreement does not say so, can it be an issue contrary to an agreement term? And so if I make an application for deposit, this will again stay at my face that this will be decided. But there has to be a clause. The agreement is binding on the parties. Absolutely binding on the parties.
I don't see anything in this application.
Well, this
37. I don't see much in this petition. At this stage.
This is lordship is deciding the appeal finally now.
I'm just telling you that I don't really see much.
So, not that there'll be another stage after affidavits. Whether lordship is considering that or not, I do not know, because then I can try my luck for another day. But if lordship is finally disposing of the appeal, on which spirit I started my arguments, then in that case I have to argue a bit more. But the lordship is considering to keep it for another stage to decide this appeal, and then I will stop.
File your reply.
It should be dismissed, my lord, with cause. It should be dismissed with cause. Well, that's what I asked, my lord, the first. My lord, I
cost and rent. You give the rent, I give the cost.
My lord, I've seen, my lord, what the contract was. My lord, I was to refurbish, my lord, a Chinakuri power plant, this Chinakuri power plant. Then, my lord, I was to erect a transmission line at my own cost. Refurbishment at his cost.
Right, Mr. Mitra, we'll keep it for another next week also.
If they want to give the reply, let them give it within that. If they want
to... my lord, this is a section 37 from a section 17.
I would rather have it decided without.
Heard Mr. Learned Senior Counsel, Mr. Abhijit Mitra. Keep it for further hearing on. When do you want?
As soon as my lord asked him.
As soon we'll have it.
Next week, lordship.
Next week. Next week we'll have it.
Next Friday.
Next Friday, yes.
Next Friday this.
Or next
Friday.
Next Friday khola ache court.
Friday corona. Next Friday corona.
Friday it's there. But Friday then we have to go. Mitra, we have that inauguration. The Jalpaiguri Circuit Bench. Friday we might have to.
So whichever day.
We'll keep it on Friday. Let's keep it on Friday. 16.
We'll see.
We'll see. No?
16.
You're not there?
Lord, if you could have it, my lord, any
19th? 19th or 19th? Mr. Mitra, convenient for you? 19th?
19th first half is possible because
we'll have it in the first.
NCLT.
You have NCLT?
Second half. First half.
20th? What about 20th?
20th.
Second half NCLT. Then the first half is
20th. 20th.
We'll have it on 20th.
20th.
Grateful. We'll show it the next day.
Call that
Grateful.
पासवर्ड है क्या पासवर्ड व्हाट इज द पासवर्ड Mr. Jeshnu Chaudhary, are the parties here?
Lord, I met the other side outside court then. She wanted to come in and mention, but I didn't let her disturb the list. May I just get her in 2 minutes, Lord?
Yeah, if you can get her, then we can decide this because then I have.
Yes, yes, Lord. Just kindly give me 1 minute. I'll request her.
In the meantime, ये कर लेते हैं ये इस कॉल
Lordship, I am on behalf of the award holder in this matter.
On behalf of the respondent, my lord, award letter number 2.
পোস্ট অফিস কৃষ্ণপুর
কৃষ্ণপুর
পোস্ট অফিস কৃষ্ণপুর থানা নিউ টাউন কলকাতা
ইয়েস নিউ টাউন কলকাতা কত
700102
700102 কি করেন আপনি
আমি অ্যাডভোকেট
অ্যাডভোকেট আর লিগ্যাল প্র্যাকটিশনার আর আপনাকে যেদিনকে বলবেন জজ সাহেব
You are a lawyer.
ভালো
He's an advocate, my lord, practicing in Barsad Court, my lord.
You should. You know, it's so embarrassing. You should. You are standing here. Finish it off.
স্যার আমি 16 তারিখে এসেছিলাম অ্যাফার্ম করে গেছি আমার অ্যাডভোকেটের রেকর্ড উনি ওনার মানে বাড়ির কোনো অসুস্থতার জন্য আসতে পারেননি আমি এসেছিলাম স্যার
That's not the point. I'm saying that you finish it off. Does it look nice that you are standing here?
আপনি একজন অ্যাডভোকেট হয়ে এখানে দাঁড়াচ্ছেন সেই জন্য জজ সাহেব বলছে যে আপনি ব্যাপারটা মিটিয়ে নিন মামলাটা মিটিয়ে নিন
স্যার আমি টাকা দিয়েছি 21,80,000 লোনের মধ্যে স্যার আমি 30 লাখ দিয়েছি আমি ডেবিট ক্রেডিট সামেশন চাইছি দিচ্ছে না এগ্রিমেন্টের কপি আমাকে দিচ্ছে না আমি চিঠিও করেছি এবং আমাকে না জানিয়ে এক্সপার্টি ওর আরবিট্রেশন করেছে স্যার সেটার নথিও আমার কাছে আছে
Ex parte arbitration. You challenge it.
হ্যাঁ স্যার আমি আরটিআই করে জানতে পেরেছি মাই লর্ড সে আমার যে অ্যাড্রেস আছে ওটা মানে ভুল অ্যাড্রেসে পাঠিয়ে এক্সপার্টি আরবিট্রেশন করেছে
You have taken money.
আমি স্যার টাকা দিয়ে দিয়েছি মানে আমাকে 21,80,000 লোন নিয়েছিলাম তার থেকে 30 লাখ মোটামুটি 30 লাখ আমি টাকা লোন দিয়ে দিয়েছি তার ডকুমেন্টস আমার কাছে স্যার আছে
You go and.
My lord, if I may indicate, they have filed a Section 47 application. On the last occasion, we indicated to your lordship that.
Like to file the
But
recalling petition for the order dated 18 December 2025, my lord. And the wakalatnama as well, my lord.
My lord, it was
Recalling
indicated.
is already the order has been executed. Now he is here. It's an arrest warrant. What are you asking for recalling?
My lord, I also beg to ask for recalling of the arrest warrant that has been issued against him, my
He's
lord.
already
because
being
the
here.
previous
Now that
order-
recalling is it is infructuous now. That application is infructuous now. He's already standing here. He's here.
My lords, they have filed a Section 47 application, but it was not listed on the last occasion. So we indicated to your lordship the application has been filed. In the application, they have pleaded that they will be filing a 34, but as of now, no 34 has been filed. not they have complied with the last order to file their affidavit of assets.
Settle the matter.
ঠিক আছে স্যার আমি
Give him the oath and file your
Not if- and
affidavit of assets.
if it is and the last location of the, if they can indicate the last location of the asset as well in the affidavit of assets, because the asset is with them.
আপনি জমা দেবেন, হ্যাঁ? এগুলো না করলে আপনারা এই যে
দেখলো, Priya. Note down. Yeah, recorded, already recorded. Award letter number 2 has been produced in the court in terms of the order dated 13th December 2025. Full stop. Oath has been administered. He undertakes to file affidavit of asset within a period of 2 weeks. Full stop. He further undertakes that he will remain present for examination or for any other purpose as and when required by the court. Full stop. Warrant of arrest is discharged. Let this matter be listed after.
My lord, may he be directed to disclose the location of the asset as well in the affidavit?
Affidavit of asset will have everything
Lodge.
after 4 weeks. File your affidavit of asset and finish it off. Does it look nice you're standing here?
Grateful, Lodge.
Applet. Okay. अभी फिर call on the list. I'll just come back in 5 minutes. Yes.
Lord, fine. Huh? Lord, Lord, my learned friend, Lord, is for the respondent numbers 4, 5, 6, and 7. And
Lordship, I'm appealing for the petition.
I'm for the rest. Lord, terms, Lord, all signed by the parties and the advocates. Effectively, my lord, replacing the award. Award, my lord, goes and fresh terms, my lord, of settlement get incorporated. Most of them worked out, 1 or 2 additional terms left.
The challenge was to the award.
Challenge was to the award.
Learned counsel for the petitioner. States that the parties have entered into a settlement agreement. The terms of the settlement agreement have been filed before this court by way of this additional affidavit.
No, my lord, by terms of settlement.
Have been filed before this court. The same is taken on record. Full stop. Learned counsel for the parties submit that since the parties have entered into the settlement agreement dated 6 January 2026, nothing survives in the award passed by the arbitral tribunal dated.
Lord, paragraph 34, my lord, kindly see, my lord, this is what date go to? 17th February, January 2025 is the award. Lord, paragraph 34, my lord, sets aside the award by consent and makes this settlement.
The parties have jointly filed the terms of settlement and have jointly prayed before this court to make the terms of settlement be part of the record of the court. Full stop. The parties,
14 December 2025.
with the consent of the parties, the award is set aside and the terms of the settlement are made part of the final order of the present petition. Anything else which needs to be recorded?
I'm grateful, my lord.
Any interim order?
That will be
stands vacated. Full stop. I think that's it. With the above observation, the present petition is disposed of.
Grateful to you. Grateful. I'm sorry, my lord. We had
Give all the appearances
Yes,
so that, tomorrow I don't want anybody to come and say, I was not there.
I'm grateful, my lord. I'm sorry for, my lord, having your lordship come back again.
No. I have to finish few more matters. So you are the petitioner. You are
Number 4567.
respond number
4567. Your
456.
For the petitioner, Lordship.
Give all the
Yes, Lordship.
1, 2, 3. It is to be whitened.
Service need to be submitted. Service I have.
I'm a 1, 2, 3. She's 4, 5, 6, 7 and petition.
arbitral tribunal date. What is the date of the award?
17th January
17th January
2025.
2025.
It is a service of what? Aadhaar card.
ठीक है sir. Grateful, sir.
Item number 14 and 15.
Bridge roof.
Your Lordship will recall that section 34 that Your Lordship had kept today.
MSME, huh?
Yes, Your Lordship. Had satisfied Your Lordship on the jurisdiction. My learned friend had taken a point that I had received the award.
We won't be able to do it today. 12:45, I have the appellate side.
Lordship, I'm aware. Lordship, only difficulty that I'm facing is that they are proceeding with their
So
execution.
we'll have it on Tuesday. We can have it on Tuesday.
Very well, Lordship.
Lordship, only one submission instead of Tuesday. If it can be taken on Thursday or Wednesday, as your Lordship.
Wednesday. We can have it on Wednesday.
Very well, Lordship.
Yeah, have you made the pre-deposit?
No, Your Lordship.
No, no,
Your Lordship was of the view that the 34, until and unless the 34 is admitted, the 34 is not born, and therefore I cannot pre-deposit. That's why Your Lordship had kept it today
No, at
for.
the time of the 34, this is MSME. At
Yes.
the time of the 34, you have to deposit the money.
Lordship, I'm ready to deposit that 75%.
At the time of 34, 34 is within time.
Lordship, I have pleaded that I have only got to know of the passing of the award when they emailed it to me claiming the sum on 6th of May. And from the date of knowledge of the award, I have filed the section 34, even though under section 31(5), the council was required to serve a copy of the signed copy of the award upon the party, which has not been complied till date. I have made a pleading to that effect, Your Lordship. If Your Lordship, because from records, Your Lordship, because at least that I have no copy of the signed award has been served upon me. If my learned friend can show that the award has been served upon me by the council, a signed copy of the award, Your Lordship, then that will be the date if my learned friend is at all able to show. Or else Your Lordship will have to call for report.
Or we have already written to the council as to the date on which it has been served upon them. And we are awaiting the answer reply from the said council. And that apart from record also, my lord, I can show to your lordship that they were aware about the award and they have appeared on the date when the award was passed. And the plea that they have taken is that they came to know from our email. That is
Award
not
has
correct.
to be given to them, not award passed. Even if they have appeared on that date, when the award is made available to them, do you have any specific record of that?
Or for that, we have written to the council asking for the reply to that effect.
Written to the council who was appearing in that.
No, to the MSME council.
MSME council. When did you write to them?
I am told that it was written around 7 or 10 days back, subject to correction. So it will take a little bit of time. So if your lordship kindly considers it and
Wednesday.
keeps it on a appropriate date.
Wednesday we'll have it.
Lordship.
We'll see that.
Grateful to your lordship.
Wednesday.
Grateful.
Call the appellate side.
I'm for the petition, Your Lordship.
$45. हाँ हो गया call out the matter. Here in one.
Yes, sir. I'm for the petitioner, Your Lordship.
Have you served the respondent?
Yes, Your Lordship.
Who was the counsel who was appearing?
In earlier writ petition, Your Lordship, Pradhan has not been represented by any counsel, Your Lordship. We have twice served the notice. They did not appear. Even the contempt application also have been served.
There was no appearance even.
Yes, Your Lordship. Order, Your Lordship. Page 56, Your Lordship.
Serve them again, the Pradhan. Learned counsel for the petitioner. None appears for the contender. Despite service, none appears for the contender. Affidavit of service, affidavit of compliance shall be filed by the respondent number 2, the alleged contender, before the next date of hearing, list on 5th February. So communicate this order.
Yes,
Affidavit of service to be filed by respondent number 2, the alleged contender. यहाँ पे देख लेना क्या respondent है प्रधान होगा. List on 5th February. We'll see that. Doesn't come.
much obliged, Your Lordship.
Item number 2.
Well, I appear for the petitioner, my lord, by your lordship's last order, dated, my lord, 28th of November. Your lordship had directed the contemners, my lord, to file a compliance report. This is with regard to the illegal construction, my lord.
This is the compliance report. Your lordship can remember this matter.
That
Your lordship,
unauthorized construction.
yes. Earlier, my lord, the order was, my lord, the notice was issued by the, my lord, chairman in council. Your lordship has set aside that order and directed it has to be in terms of 208. Correct. But in terms of 218, the board of councillors has taken a, my lord, decision, which is an appealable order.
Right.
In terms of 218 subclause 3.
Right.
So, my lord, this is our compliance report. Your lordship's complement, the direction to comply with 218 subclause 1 has been complied with.
Well, maybe get a copy, my lord, of the. We have not been given a copy, my lord, in spite of asking, my lord.
Yes. They did not serve a copy of the contempt application. Only upon persuasion.
My lord, that is, my lord, we have served on all, except, my lord, we have served on all the contemners. I have the affidavit of service, my lord, except 8, 16, 17, it has been refused.
Affidavit of compliance filed by the municipality, Darjeeling municipality, is taken on record. Learned senior counsel for the municipality states that the order has been duly complied with. Full stop. A copy of the compliance report is handed over to the counsel for the petitioner. He seeks time to go through the report Let this matter be listed on 5th.
My lord, it has not been handed. My lord, only one original copy may be handed over to the petitioner, my lord.
See, right
Yes.
now I can give it to him. Right.
My lord, this is a Xerox, the original.
What do you mean original?
My lord, because as my learned senior friend submitted, the appeal against this lies before the civil judge. Now, till the time I don't get a copy, my lord.
Give a copy to him.
That is the whole. Yes, my lord, that is the whole.
I shall give it.
Give a
My lord,
original
you can
copy so
record
that he
my
can-
submission. My
Yes.
lord, original copy I will give it to him.
फिर उसको थोड़ा change कर दो. A copy of the
Original
same
attested copy will be given to
a
him.
copy of the same shall be a copy of the original compliance report, attested original compliance report shall be handed over to the council for the petitioner within the course of the day.
No, it has to come from Darjeeling. So in course
Within-
of next week, we will give it to him.
Shall be handed over before the next date of hearing.
Yes.
List on 5th. उसको हटा दो. दरकार ठीक है. We'll have it on the 5th. We'll finish it off.
Lordship.
Great.
You take your remedies in accordance.
Yes, my lord. That is till the time I don't have the original order, I cannot take steps.
Deeply appreciated.
Great.
ये वो original side वाला बुला लो. Few matters will finish off. 16, 17, 18, 19, 20. Call out a few matters. Yes.
Lordship, it has recently come to our knowledge that the
Which matter?
respondent in the instant case, that is Tata Motor Finance Limited, has been merged with Tata Capital Limited by the order of learned NCLT. So we require some time to make the necessary amendment.
Item number 16 to 20 are the similar matters, Lordship. Same parties. In respect of 5 different loan agreements, 5 awards were passed. And these are the application under section 36(2).
All right. Learned counsel for the petitioner.
Lordship, one humble submission. If in the meantime the respondent gets their hands on the loan agreement, kindly it be served upon us as well.
It is their contention in their section 34 application that they have never been served with the copy of the agreement. And on the first occasion, your lordship was pleased to direct us to get the agreement and to show that whether it has been given them or not. So I have the copy of the agreement where they have duly signed, and the agreement in the arbitration clause, it says that the venue will be, the seat of arbitration is at Mumbai. So our preliminary point in section 34 application is the jurisdiction point that this honorable court doesn't have jurisdiction to entertain the same.
This is a 36 too.
Yes,
See,
this is the
36
36-2 application.
What about 34?
34 are running in the monthly list as item number 150 to 155. 151 to 156.
All right.
It is running in the monthly list option.
Monthly list numbers
151 to 155, Lordship.
Learned counsel for the petitioner states that the Tata Motors Finance Limited has merged into
Tata Capital Limited.
Tata Capital Limited. She seeks and is granted 2 weeks time.
3 weeks.
3 weeks time to implead the necessary party to take appropriate steps in accordance with law. Let this matter be listed to implead Tata whatever finance will be as the party.
They have to amend it because
to amend.
Tata Motors Finance Limited has now become Tata
They have
Capital.
to amend it to take necessary steps in accordance with law.
Okay.
3 weeks to take necessary steps in accordance with law.
And in the meanwhile, if your lordship directs us to serve them a copy of the agreement, we can serve them. But it is their contention that they have not received it. But they have never.
Give it to them. Give it to them. It doesn't matter.
We will. Achha.
Maybe that will change their mind. They'll go to Bombay.
Not sure. I'll
They'll withdraw all the petitions and go there.
Not sure. I'll serve them the agreement today itself.
4 weeks.
You know.
And you consider that the objection which is being raised by them, if the loan agreement actually puts a seat, and the seat is very clear, judgment have been passed by this court, and the Supreme Court itself has decided seat of arbitration will decide the jurisdiction.
Lordship, let them
On the
once
very first occasion,
serve
your
the-
lordship has indicated the same when learned counsel, I give Anuj Sinha,
the
he was
learned
appearing.
counsel was
Your
there.
lordship was very much.
Lordship, let them serve the
They'll serve you,
the
but
loan agreement then.
they will not lie about the clauses, no?
No, I'm
We'll come back.
1620, same order.
Same
order.
lordship. Grateful, my lord.
Separate.
21, my lord, I am for the award holder, my lord.
I am for the same.
Lordship had directed me to file an affidavit in opposition. I'll be very candid, my lord. I am in default, my lord. I was praying for 2 more weeks' time to file my opposition on a very limited ground of, my lord, the limitation aspect of it.
Your Lordship,
2 more weeks.
in this matter, the final award has been passed. We need time to file.
Also has been passed.
So we need
What is left?
we need time to file Section 34, Your Lordship.
Oh, you
And they
always
may
have
do
the.
that in there.
So this is what.
This is from an interim award.
This is for the interim award.
And now I'm.
My lord, then Lordship will dismiss it and let them, because
We'll
I am
file
the award
Section
holder,
30.
my lord. The award is in my favor.
So are you still challenging the interim award also?
We'll file consolidated in the Section 34 here.
So you withdraw this.
I'll take that instruction, Your Lordship.
You take that is when will you take that instruction? You don't have that instruction.
So according to what I have, as per today, Your Lordship, we will file 34. We'll take this back, and 34 has been will be filed.
So then I'll record that.
By Your Lordship.
Learned counsel for the petition seeks to withdraw the present petition since the final award has been passed. Full stop. He seeks and is granted liberty to challenge the same in accordance with law. Dismissal.
Grateful.
Much obliged, Your Lordship.
The rest of the matters later.